Judge Nancy Lichtenstein. To my left is Judge Karen Ashby. We have two cases set on our 1:30 docket this afternoon. I take it counsel are ready to go on Myrtle Hill versus Washington Park United? Okay. Are the counsel present for Leverage versus City of Thornton? Okay. When you came in, you should have received some written instructions on oral argument procedures. Did you all receive that? Okay. Do you have any questions about that? Okay. The only thing I'll say at this point then is remember that oral arguments are being streamed live and that they're being recorded on our website. Please be careful about saying anything that's confidential or sensitive information. And when you come to the podium, please give us your name and attorney registration number. And for anybody else in the audience, please turn off your pagers or your phones so as not to disrupt the oral arguments in the case. Okay, I think with that we can begin the arguments in Myrtle Hill versus Washington Park United.
Good afternoon, Your Honor. Lindsay Smith for Myrtle Hill Homeowners Association, attorney registration number 35875. This case arises out of the interpretation of an easement agreement entered into by appellee Washington Park United Methodist Church and the association's predecessor and developer, CLHC. At trial, the district court held that the easement agreement was not ambiguous and determined that Washington Park was required to remove an additional recycling dumpster it had placed in the alley that was created by, or that was burdened by this easement agreement, but also determined that Washington Park was not required to remove a makeup air unit, bollards, gas line, and concrete pad that were also installed in the easement. This interpretation is incorrect because it neglects the plain language of the easement agreement, which expressly forbids the installations of any structures or buildings in that easement and requires Washington Park to remove any obstructions or improvements in the easement. The easement was entered into, executed in 2006 by a representative of CLHC and Kevin Aronymous, who at that time was chair of the Washington Park United Methodist Church Board of Trustees. Mr. Aronymous has been involved in Wash Park for many years. At the time of the easement, he was the chairman of the board, and he was also the architect who was the creator of this project that resulted in this litigation today. When the easement was signed back in 2006, there was an evaporative air cooler, a shed, yellow bollards, and some other minor improvements located in the alley. Those improvements served the church itself. CLHC, the association's predecessor, and the association didn't seek to compel removal of these improvements at any time, including during this lawsuit, but their decision to not require removal of those improvements was not a waiver of the right to compel the removal of subsequent improvements added by Washington Park. And it was also not consent to Washington Park for it to construct these structures in direct contravention of the plain language of that easement agreement.
Ms. Smith, oh, go ahead.
Oh, go ahead.
All right. I wanted to ask you about the phrase included but not limited to, because I do understand that they did compel removal of some items and not others, and those that they asked to be removed were listed in the easement agreement. So is included but not limited to the things of like kind, or was it any type of improvement that it covered?
In this case, it says including without limitation, and I know that the doctrine of adjustum generis would say that things of like kind have to be removed. Here, even those things of like kind would have to be removed. The makeup air unit is very similar to an evaporative cooler. Even if you narrow the interpretation to that adjustum generis doctrine, the makeup air unit is essentially an evaporative cooler. The exhibits in the record show it listed and described as an evaporative cooler. It's an evaporative cooler that also provides air conditioning type services. That's why it's got a gas line to it, so it can do heating and that sort of thing. So even if you were to limit including without limitation to just items of like kind, you would still have the same result. One, they don't have the right to install any structures whatsoever. And two, any improvements or obstructions in the alley have to be removed by the church at its own expense.
Let me follow up with one more question. What about the bollards and the gas line concrete pad? Because those are different from shed. So
There were bollards that were pre-existing, and there are existing bollards. I would argue that the bollards that were recently installed, the yellow bollards, they're appurtenances of that makeup air unit, and they're not necessary. Without the concrete pad and the bollards and the gas line are only made necessary by the makeup air unit, which is, again, a structure that is not permitted to be installed even without considering what items have to be removed without limitation.
Counsel, you indicated that improvements have to be removed without limitation. What do you make of opposing counsel's argument that, wait a minute, there's a term there that qualifies it all, improvements cited on the property, meaning like the past tense of it suggests that only the improvements then existing have to be removed as opposed to improvements put on there in the future?
If you'll let me grab the easement agreement, I've actually considered that. Hold on. You'll always find something in the last place you look. So it says the improvements, it says, notwithstanding anything contained in the foregoing to the contrary, the church does not have the right to construct or install buildings or structures, and any improvements or obstructions cited upon the easement, including without limitation, shall be promptly removed. So he's saying currently cited. It doesn't say currently cited. Cited means it's on that easement area right there. So he's reading in currently. That doesn't say currently. Regardless, the church did not have the right to build structures or improvements on the easement, and they did.
Structures or buildings, I thought it said.
Black's Law Dictionary says structures.
I thought it said that you don't have the right to put structures or buildings, but you're going to say what structures mean.
Yeah, structures, according to Black's Law Dictionary, are any construction, production, or piece of work artificially built up or composed of parts purposefully joined together. So under that interpretation, it would be a structure. Further, under the interpretation that a structure would only be 4 walls with a roof, the dumpsters, which the court determined did have to be removed, the additional dumpster, would not be a structure. So limiting structure to only an actual building is unnecessarily tight.
Who would have limited it to natural building? It said buildings and structures, I thought it said.
It says buildings or structures.
Buildings or structures, that's true. But doesn't the or mean that structures could be something different than building?
Yes, such as a makeup air unit. In addition to Washington Park's decision to install the makeup air unit and its appurtenances on the easement without the association's permission, the way they went about this was it shows unclean hands and it shows bad faith on behalf of Washington Park. In April of 2014, Kevin Hieronymus, again the person who signed the easement agreement, and Washington Park decided to put the makeup air unit in the alley as opposed to any other location. The testimony and the evidence indicated that the engineer involved stated to Mr. Hieronymus that it could be placed on the roof or in the alley and that it was Mr. Hieronymus's call. Mr. Hieronymus, in April of 2014, made the call to put that in the alley. In January of 2015, the renovation plans were submitted to the City and County of Denver for approval. They were approved, and in April of 2015, a year after they'd already decided to put this in the easement, they came to, Wash Park came to the association to discuss construction logistics, but again, they didn't ask any permission, they didn't bring up the easement, they didn't indicate the scope of their intended alterations to that alley.
Council, can I just ask you a question? There were kind of some discussion on both parties' sides about, well, they didn't talk about how much it would have cost them to put it on the roof as opposed to putting, why would that be relevant to what we're trying to determine here?
There might be a question of waste, but they didn't prove that it would be wasteful or that it would be inappropriate to have it be in a different location. There was only speculation. There was no evidence presented that it would be improper to place it on anywhere that Washington Park else controlled. From what was evidenced in the documents at trial, it appeared that this was more of a after-the-fact determination, that this was really the only place that Wash Park thought it could put the makeup air unit, but that doesn't alter the fact that they didn't have the right to do this. They did it notwithstanding the plain language of the easement agreement that said they could not construct this in the easement.
So if they didn't have the right to do it, would prohibitive costs necessarily have created some right for them to place it there?
That would be an equitable determination by the court, and again, we have an unclean hands issue here, and I don't think that equity would be served by rewarding the entity that didn't come to the association until after the plans had already been put into place.
Did the trial court make any findings on unclean hands?
No, the trial court did not.
How could we make it?
I'm not asking you to, but I am saying that there was no ambiguity in the easement agreement, and therefore it has to be interpreted in accordance with its actual plain language. The defendant did claim that the easement agreement was ambiguous, and therefore they were entitled to reformation. No reformation occurred because it's not ambiguous, but at the same time, the plain language of the agreement was not fulfilled. So when Washington Park first notified the association about its renovation plans a year after it had finalized its decision to put the makeup air unit in the alley, the communications dealt with logistics and what alleys might need to be closed temporarily for construction traffic, porta potties, that sort of thing. They never actually said to the association, hey, we plan to install a makeup air unit that's 3 times, 4 times the size of the existing encumbrances in the alley. The natural result of Washington Park's argument is that the entire 16-foot width of that alley can be narrowed simply because maybe it would be reasonable in their interpretation. But that's not what the document says. And the association is entitled to an order requiring the district court to compel removal of all improvements or obstructions located in that easement at Wash Park's expense, and a determination that the association is a prevailing party for purposes of cost shifting. I'll reserve the rest of my time.
Thank you. Good afternoon, Your Honors. Richard Marsh for Washington Park United Methodist Church, attorney registration number 14481. May it please the court. When this easement agreement was signed in 2006, the alley's narrowest point was 12 foot 1 inch. The trial court so found, and this is still true today. Because of that fact, in 2006, the easement agreement necessarily contemplated only a 12 foot 1 inch wide single lane for east-west vehicular traffic. This is a circumstance, in quotes, as I argue in our brief, within the holding of Lazy Dog Ranch. This agreement did not contemplate variable widths for vehicles up and down the alley, with wider in some places and narrower at the middle. And it serves no useful purpose to force a 16-foot wide width in part of the alley when the passageway is really limited to 12 foot 1 inch. It also serves no useful purpose to ban surface use of the alleyway next to the church, as was done here. This is particularly true when the trial court found, and the association really does not challenge, that this MAU equipment does not interfere with or otherwise obstruct vehicular access up and down the alley.
Mr. Marshall, let me ask about that, because I do know that one of the recitals in the easement agreement refers to, did it unreasonably interfere? But then there's another recital in the agreement that says that the church shall not install any building or structure, and that any of the items cited upon must be removed. Can you address that portion of it?
I sure can. The MAU, I'll say multi-purpose air unit, is not a building or structure as contemplated in those two words as used in the agreement. There's no reason to think of those terms as anything other than something with a door that people can walk in and out of. Further, that's a prospective use on building or structure, and we don't have a building or structure here. Here, the MAU is a piece of utility equipment with bollards, very similar to the other piece of utility equipment that was in existence at the time this agreement was drafted and signed, that being the gas meter and the so-called silver bollards. The MAU is not an improvement or an obstruction as used in that same passageway, the reservation of rights. The improvements or obstructions, as was already alluded to in a question earlier, related to those in place at the time. namely an evaporative cooler, also known as a swamp cooler, a storage shed, and a trash receptacle. You can see those in Exhibit 77 or Exhibit 134, the photographs in those two exhibits.
How can we
The-
tell that it was limited to only those in place at the time?
I did
How-
not
How
hear you,
can
sir.
we tell that it was only limited to those in place at the time?
The words cited upon, I think, are critical. It's used twice, those two words. They're used in recital C on the first page of the agreement, where it talks about the private alley currently cited upon, improvements currently cited upon. Then it's used in the reservation that we're talking about, Section 2B, where it talks about cited upon. And then it goes on to recite three things that were currently cited upon. I don't think it's unreasonable to infer that the drafter of this document used the term cited upon in the same sense in both places. An example, and getting to your earlier question to council, of including without limitation, an example of something that's not included within those three items that was present at the time is the asphalt, something that opposing counsel makes a big deal of in their briefing. So there are items that were in place, that were cited upon at the time, cited upon the alley at the time the easement agreement was drafted, that readily fit within the language that you questioned me about.
Well, let me follow up with that, Mr. Marsh. So you're saying that would also include the asphalt, and I'm just looking at recital 2B of the easement agreement, and it really does discuss any improvements excepting the church alley improvements. And I understand that there's an argument that the church alley improvements refers to the asphalt. So would the asphalt, accepting that interpretation, be excluded from what we're discussing now?
No. I think the church alley improvements were accepted. I think they meant by church alley improvements, the things that were currently cited upon. And I understand you're suggesting that it would be inconsistent to list some of those when it has already accepted those from the definition. I don't believe so. I think they wanted the old pieces, they wanted the old swamp cooler out, they wanted the old shed out, and they wanted the old, and they wanted to deal with the dumpster. And as you know, the dumpster remained in place thereafter.
And also the evaporative cooler, or did you just mention the evaporative cooler as well?
Council's argument, the evaporative cooler, as used in the agreement, refers to the swamp cooler that was in place, and that's in the pictures that are in evidence.
Counsel, I have a question. You indicated to us cited is used 2 or 3 times in the agreement. Is there a difference between currently cited and just cited? In other words, does it make a difference that the provision we're talking about does not use the term currently cited?
I think it makes a difference when you ask the question, does the agreement expressly prohibit the use of this surface area by the church in the future? I think you have to take into account what the Lazy Dog Ranch case stands for, which is look at the circumstances at the time. How can the parties here have intended not to use any portion of the surface of that side of the alley when the fact is they can go up and down the alley at most in a single lane, and then only to the extent of 12 foot 1 inch. I think it's reasonable to assume, and it's in the Reservation of Rights, the first sentence, that the church can make any reasonable use of the surface, so long as it does not reasonably interfere with and is not otherwise inconsistent with the purposes of the agreement.
So I take it then your thought is that although the word currently is not in 2B, it should be in currently cited. We should imply that in there?
I've made that argument, but I'm also saying I don't think it makes a difference. I think the fact, I don't think that last sentence of the reservation in 2B prohibits a surface use of an area not intended to be used for vehicular access. That's my point. Continuing with the, since I touched on it, the Lazy Dog case, I believe that case has application here. Obviously, the trial court did too, and I think this panel needs to decide how it applies. I've mentioned the use of the word circumstance in that decision as pointing to what was on the ground at the time, and that's the 12 foot 1 inch wide vehicular access area. The easement agreement at Section 2B in the first sentence, as I just said, also permits the church to make reasonable use of the easement area, so long as it doesn't interfere. In their opening brief, the association acknowledged that the church has the right to make improvements or modifications to the improved private access alley, as long as the improvements or modifications, don't unreasonably interfere with the association's use of the easement. The association, there really was no issue at the trial made by the association as to whether this MAU unreasonably interferes. The only evidence that was offered by the association was the testimony that the trial court found lacking in credibility. I think one of the messages of the Lazy Dog Ranch case and the Roaring Fork case and other progeny is that the Supreme Court wants us to favor maximum use of property. And if it serves no purpose and it's not clear that surface use is banned, and it serves a purpose, as it does here, to help the church modernize its child care center and upgrade its air handling system, that is a reasonable and balanced use of the church's property, and I think the trial court so correctly held.
Mr. Marsh, let me ask you, I'm looking at Section 2B that says the church shall not have the right to construct or install buildings or structures.
Yes.
All right, and so that looks like it's a blanket prohibition. Is it your argument that we need to read that in conjunction with Section 1A that says so long as it does not reasonably interfere, or do you agree that the prohibition on installing buildings and structures is a blanket prohibition?
I think if this panel were to find that a structure is not similar to a building, that a structure could be what I'm standing in front of here today, a podium, something made out of nothing, then if you give it that broad reading, then I suppose it could include a piece of utility equipment like this. I'm arguing that's not how it was used. It was used as building or structure in the framer's mind as similar items, as like category, like kind items. That's my argument.
All right, well, let me just follow up with that. So is that limited by so long as it doesn't interfere with the use?
I don't believe
Or
so.
is it a blanket?
No, I
It's
don't
a
believe it.
blanket prohibition?
Yeah, I believe it
Okay.
is, but I think it's limited to, as I said, to something that has a door and that you can walk in. We've touched on most of the points I wanted to make. Let me just check my notes. This MAU is not an evaporative cooler for several reasons. Again, there was an evaporative cooler on the ground. I've already made that argument. Next, the association to argue that it is that the MAU is equivalent to an evaporative cooler relies on a page in the city-approved plans, some 25, 30 pages in length, that were created in 2014, 2015 to read back in time as to what evaporative cooler must have meant. I think that's an improper use, and certainly the trial court didn't think that that made a difference to him, and the trial court correctly refused to treat the MAU as an evaporative cooler. Let me touch on church alley improvements just briefly. There was some briefing on what that meant, and I've already argued about the currently cited upon in recital C to the agreement. Our point here is that the developer, with that currently cited upon definition for church alley improvements, was implicitly recognizing the other items that were on the ground and that were left on the ground at the time, namely the silver bollards, the stairwell, which is not a minor improvement, by the way, and the gas meter. Those things remained in place, and the light pole. Those things remained in place after the agreement was executed. That's our point, is that it sheds light on what the developer must have intended with respect to the use of the 16-foot wide easement where it wasn't limited. And our argument is that use, the surface use, is not limited it's not prohibited. Rather, the surface can be used for something that's reasonable and that doesn't otherwise interfere.
So is church alley improvement just the surface? Is that what you're?
No.
No.
Church alley improvements is the asphalt, but I've argued that it is also the other items that were in place, and I don't need to recite what those were. We've also cross-appealed on the prevailing party issue, and I would ask you, clearly the argument today has consumed it is consumed with the MAU and with the bollards and with the cement pad. Very little with the movable dumpster, and that really wasn't contested at trial. And we're asking you to reverse the trial court's ruling that neither party prevailed. And in closing then, I would say that the case was correctly decided under Lazy Dog Ranch by recognizing that the church, as the owner of the fee, retained the right to surface use of the alley that doesn't unreasonably interfere with the association's vehicular and pedestrian use of the alley. The trial court correctly held that the easement agreement does not expressly prohibit the church's placement of the MAU on its side of the alley. The trial court correctly held, and the association doesn't challenge, as I said before, that the MAU does not unreasonably interfere with use of the alley by cars. We ask the court to affirm Judge Grant and to rule in favor of the Washington Park United Methodist Church and to award fees and costs to the church. Thank you.
Counsel for Wash Park says, I think they meant, and he talks about the party's intent, but there was no evidence of the party's intent introduced at trial, notwithstanding that the only witness who might have had any real understanding of the party's intent was Washington Park's witness, Kevin Hieronymus. He didn't talk about his intent. He said he understood the meaning of that easement when he entered into it, or when he entered into it on behalf of the church. So to try to pin the party's intent it's solely an argument of counsel at this point, and it should not be considered. The party's intent is reflected in the four corners of this document. To the extent that there is something that is not directly addressed, such as, for example, use of that surface in a way that is not prohibited expressly by this easement, maybe they want to queue for a Halloween haunted house and enter through the back door through that alleyway. Maybe they want to organize a 4th of July parade, and that's the right place to get everyone in line. Those sorts of surface uses would not unreasonably interfere with the association's use of that private access easement. And those would be permitted under the same analysis of Lazy Dog Ranch. But here we have an easement that expressly prohibits the construction of structures within this easement. And notwithstanding the idea under Lazy Dog that the context of a easement at the time it's entered into is important, it's more important for the association to be able to rely on an unambiguous easement agreement that says what it says, and that is that the church does not have the right to install these structures, and it has to remove these structures. The argument regarding church alley improvements is another red herring. Church alley improvements, it's easily defined. It's in the recitals. It's the currently cited improved private access alley. It has nothing to do with the evaporative cooler or anything like that. The way that we know this is because the association under this agreement is obligated to maintain the alley improvements, and that includes the church alley improvements. There's no argument that can be made by anyone that the association has ever been required to maintain the improvements that were located in the alley by the church, such as the evaporative cooler, such as the bollard, such as the makeup air unit. The association respectfully requests that the Court of Appeals read the easement agreement and instruct the trial court to enter an order compelling removal of all these structures and improvements located in the alley. It's an unambiguous easement agreement. The association is entitled to an order enforcing that easement agreement and for removal of all these obstructions at Wash Park's expense. Thank you.
Thank you, counsel. Thank you both, counsel, for your arguments. They'll be very helpful to us in resolving this case. The case will stand submitted, opinion will issue in due course. Thank you. Whenever you're ready, counsel.
Good afternoon. My name is Jody Bramer-Helter. My registration number is 36966. I represent the plaintiff below, Kara Loveridge, who is with me today. I'd like to thank the court for affording the parties the opportunity to present oral argument today. Before I begin, I would like to reserve 5 minutes for rebuttal.
Counsel, you're in control of your own destiny. You should be able to see your time in front of you.
Thank you.
Okay.
May it please the court. I would like to focus on a series of errors made by the lower court. First, the defendant and the court have conflated the terms reasonable accommodation and return to work agreement. Second, the court erred by finding that a mandated visit to a doctor or an in-home assessment by a stranger is a reasonable accommodation. Third, the court erred by determining that negotiation of the terms of a return to work agreement met the requirements of the interactive, meaningful dialogue required by the CADA and the ADAAA. That's court file page 130. Finally, based on these errors, the court mistakenly found that plaintiff's claim for constructive discharge failed. It was during the negotiation of the terms of the return to work agreement that plaintiff was told by the assistant senior city attorney that she must sign the return to work agreement or be fired. Court file page 12. The motion to dismiss states that the plaintiff resigned, quote, during negotiations of the terms of the return to work agreement, end quote. The defendant said the return to work agreement, again I quote, sought to regulate her conduct and provide an incentive to remain sober, end of quote. That is not an accommodation.
Counsel, did the court actually find that the return to work agreement was the accommodation?
I believe so, Your Honor. I have the order.
I thought the court was saying the accommodation was the reply to your client's suggestion that having to report to a medical facility won't work. I thought the court addressed that as the accommodation, not the contents of the return to work agreement.
I think, Your Honor, that the court, again, conflated the return to work agreement with a reasonable accommodation, and therefore believed that a modification to the agreement was an accommodation, when in fact that's not the case. The defendant said about the return to work agreement that it sought to regulate her conduct. In general, an accommodation is any change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. A return to work agreement is not an accommodation. Defendant incorrectly states that imposing conditions on an employee who is an alcoholic constitutes reasonable accommodation and does not violate the ADA. Although a return to work agreement is permitted when an employee's work is affected by substance abuse or the employee is impaired while at work, none of the cases cited by defendant say that a return to work agreement is an accommodation. Even though permitted, a return to work agreement is not an accommodation for several reasons. First, no modifications or adjustments were made to the work environment. In this case, the plaintiff was not disabled by alcohol dependence. The plaintiff did not request any accommodations for alcohol dependence. The defendant wanted to hold the plaintiff to a higher standard than other employees, and the defendant wanted to control the plaintiff's behavior. Although the agreement states in large letters that it is signed voluntarily, it was mandatory. The plaintiff was told, sign or be fired.
But the discussions continued after that, didn't it, counsel?
The discussions continued, and they were regarding the return to work agreement.
And they were also regarding the condition about whether or not your client would have to report to a medical facility or whether there was a different option. Did not the discussion talk about that?
Yes, and that discussion was a negotiation of the return to work agreement.
Was that the case, or was it a negotiation of a term in the return to work agreement?
It was a negotiation of a term of the return to work agreement, but it was not an offer of an alternative accommodation. An accommodation does something, the employer does something to modify the work environment or the conditions to enable a qualified employee with a disability to continue to fulfill the essential functions of the job. Asking a person to go to a medical facility or having a stranger come to her home does nothing to modify the conditions of employment.
And you think that your client had an absolute right to do self-reporting without any monitoring by the company as to perhaps an alcohol problem?
I do, Your Honor, because the cases where courts have upheld a last chance agreement or a return to work agreement are cases where an employee has been impaired at work, has been arrested due to driving while intoxicated, or has had other conduct problems related to the alcoholism. None of that is true in this case. In fact, in this case, the employer would not have known that Ms. Loveridge had any kind of an alcohol problem, except that it used information from her FMLA form to decide that she had a disability related to alcohol.
Also that she was missing from work for some time.
Yes, but asking for FMLA leave should not say to the employer, you get to decide that this is a disability.
Well, did it decide it was a disability, or did it decide that it was a condition of work that needed monitoring?
The return to work agreement would seem to say that it was a condition of work that needed monitoring, but the employer said that it wouldn't, that allowing her to self-report would have allowed her to evade the city's sobriety requirement, which meant that it was not a plausibly reasonable accommodation. So they conflated the two. She asked for a reasonable accommodation for anxiety and depression, which were co-diagnoses. For that, for those diagnoses, the ability to work or to fill other activities of life when she is suffering a relapse of those illnesses means that it's almost impossible for her to do any kind of self-care on those days. Asking her, saying, well, you can't self-report on those days because, not because we don't think that you have those illnesses, but because you might have been drinking. It puts a discriminatory emphasis on this return to work agreement. It doesn't do anything to accommodate her. So when she said, when she was told, you must sign this or be fired, she chose to resign because the terms were so discriminatory. The fact that there was dialogue about modifying the return to work agreement is not the same as dialogue, an interactive dialogue about an accommodation. They refused her modification, which would have been an accommodation.
Well,
But
did she make any requests about accommodation that were not addressed in the agreement or that were not addressed in an interactive process?
It's hard to separate what was interactive process and what was negotiation of the agreement. She did ask that she be allowed intermittent leave and to self-report when she was experiencing the symptoms of anxiety or depression. When she asked that, they said, no, because you might be drinking.
Well,
And-
but they,
Go ahead.
sorry, they didn't say that they wouldn't be willing to allow her to stay home to accommodate the depression and anxiety. Wasn't their response, they just, if she were going to stay home for purposes of doing that, they then had a right to determine whether she was staying home for that purpose or
They did
For-
say that.
for
and
the other
They did
reason.
say that. And again, that is an attempt by the employer to control her behavior, both at work and out of work, when nothing about her illness, nothing about her alcohol dependence had ever impacted her work environment. So they had no right to try to control her behavior outside of the workplace because she had never done anything that violated any work laws or work.
Why was that trying to control her behavior outside of the workplace as opposed to just verify whether she was using the accommodation that she had a right to use?
Because that was their language. They said they sought to regulate her conduct and provide an incentive to remain sober. That was their purpose behind the return to work agreement. And while a return to work agreement is allowed, it is allowed when an employee has been, has violated workplace rules due to alcohol or when they have been impaired on the job. And none of that was true in this case. So the employer assumed that her illness was a disability. The defendant rejected plaintiff's request for the reasonable accommodation without justification. There was no undue hardship, no safety concern. Defendant's response that someone would come to her home is, again, not an accommodation. It only serves the employer's bizarre belief that the only reason the plaintiff would ever be absent from work is due to alcohol use. I'm going to reserve the remainder of my time. Thank you.
Good afternoon, Your Honors. My name is Brent Case, number 36623. I represent the city of Thornton. Mary Gray, my colleague, is with me today. May it please the court, I think actually this is a pretty simple case. The issue of whether the return to work agreement was permissible in the first place is not before you. That wasn't appealed. The issue, as I think Judge Daly described in one of his questions, is whether the city failed to accommodate the plaintiff's conditions of anxiety and depression. And the issue came up when, after the plaintiff returned from a long absence due to inpatient treatment for alcoholism. They negotiated a return to work agreement. And during that negotiation, I think it's pled, and I understand this is what is argued in the appellate briefs. The plaintiff requested an accommodation with respect to one of the terms in the return to work agreement. And the particular term was, as we've discussed, the requirement that if the plaintiff had an unscheduled absence, that she be required to submit to testing somehow. The initial agreement indicated that the plaintiff would have to report somewhere to a testing facility in the event of an unscheduled absence. And the plaintiff noted that and asked, as counsel indicated, that she be allowed to self-report. I understand that she was proposing an accommodation. The city considered that, it's in the complaint, and responds that that doesn't work, but how about something else? How about, if you feel that you can't leave the house, we'll come to you. And rather than returning serve, hitting the ball back, the plaintiff resigned her employment. Now, the courts hold that in an instance like that, where there is a discussion concerning potential accommodations, and the employer responds with another accommodation, and the employee resigns in the middle of that process, that the plaintiff can't bring either a disability discrimination claim or a failure to accommodate claim based on that. And we've heard claims about that, or it seems to me that the appellant is trying to draw a distinction between the interactive process and the negotiation of the return to work agreement. The reality is that the law makes no such distinction. The regulations associated with the interactive process indicate that, well, for one thing, it's not even required. You can't state a failure to accommodate claim by just saying that the employer didn't engage in the interactive process alone. Furthermore, the regulations indicate that the process can be informal. It's the interactive process is supposed to be a back and forth discussion about what the employer can do to take care of the limitations that an employee has in the workplace. And there was no real, not in the complaint, not in the record, any discussion of what the actual limitations are. In fact, the record contains no mention that the words depression or anxiety were even uttered.
I'm not sure about that, counsel. In the complaint, the words anxiety or depression are not uttered. I thought it was in the complaint as well as the alcohol, perhaps dependency.
It is in the complaint, Your Honor, but there's no allegation that during the interactive process, during the negotiation, that the plaintiff said, I can't, this term that you're imposing on me doesn't work for me because my anxiety and depression doesn't allow for this to happen.
So do you think that the plaintiff, when the plaintiff was resisting this particular requirement, meant to say that this alcohol dependency issue is what I'm relying on to say that you shouldn't be allowed to do this?
I don't think so. I take the complaint on its word. However, I think that in the midst of the interactive process, that the employee, the employee is the one who knows best about the limitations that they have as a result of whatever the disability is. And so it's incumbent upon the employee to indicate that because of my condition, this particular thing doesn't work for me. So then the employer can say, okay, well, what about this? What about this proposed alternative that maybe would accommodate your disability and also reach our employment end? So I think that it's not a one-way street, this interactive process. It's a two-way street. It takes two to tango, if you will, here, where there's no indication besides argument of counsel, I think, why what the city proposed with respect to this testing requirement on days when the plaintiff was absent on an unscheduled basis, why that wouldn't work for her anxiety or depression.
Did the trial court find that that was a reasonable accommodation?
I believe it did. I believe that. However, I don't think it necessarily. I think it almost went there, but I don't think it necessarily went to, because what the trial court found, I believe, is that they were engaged in the process, and by virtue of the employee abandoning the process before a solution could be reached or not, that basically stops the plaintiff from making a claim like this.
Well, Mr. Case, your opposing counsel is saying that coming over to check to see whether she's drinking or not is not an accommodation. And what's your response to that?
Well, my response is that throwing an idea out there, that's exactly what you're supposed to do in the interactive process. I don't see how it's not an accommodation. I mean, the idea is that I infer that the idea is that in the agreement, it says that if the plaintiff was absent on an unscheduled basis, that she'd actually have to leave the house. And so I infer that the city believed that to be problematic, or that the plaintiff believed that it was problematic to leave the house. So the accommodation is, okay, you don't have to leave your house, we'll come to you. And I think that's the very definition of an accommodation. It's the employer changing something it wants to do in an effort to try to address whatever limitations that the plaintiff has or the employee has with respect to their disability. So it is accommodation.
It seems as though the argument, though, was that it was an accommodation related to something that wasn't in fact the disability that she was saying she had, that there wasn't a determination that the alcoholism was a disability, and so that accommodation didn't directly relate to the issues that were the disability, and therefore it couldn't have been an accommodation for the disability.
I think you're right about that argument, or about that recitation of what the argument is, but I disagree with the argument. I think that when a plaintiff comes into court and indicates that the employer failed to accommodate my disability, then what the employer, how the employer conducted itself with respect to the claimant's invocation of that disability with respect to a term and condition of employment is directly relevant. I think that you're right, that's what they're saying, but I don't understand how that helps with the plaintiff's case. Another point to get to, even assuming that the city hadn't come back and the plaintiff abandoned the process after the city offered an accommodation, based on the record, even if the city hadn't done that, the city would still prevail, because an employee can't prevail in a failure to accommodate case when it has not proposed a reasonable or a plausible accommodation itself. It's plain to see that the employer end of the return to work agreement was to ensure that the plaintiff remained sober, didn't use alcohol or drugs. That's the particular term that we're talking about in this appeal concerned the city's mechanism to try to ensure that the plaintiff employee was unable to evade the sobriety requirement by simply calling in sick, staying home sick when she possibly could have used the night before or that day. And what the plaintiff proposed as an accommodation here would allow her to do exactly that. So we're taking the position that that's not a plausible accommodation, and there's case law in the briefing that supports that an accommodation that allows the employee to evade a work rule is not a plausible accommodation that can serve as a vehicle for bringing a failure to accommodate claim.
That wasn't the basis of the trial court's ruling, was it?
No, Your Honor, it wasn't. The trial court didn't need to reach that, so it's an alternative basis for your affirmation of the trial court's decision. There's yet another basis. About a week ago, I think today, on the deadline for providing supplemental authority, I cited a new 10th Circuit case that held for the first time that you can't bring a failure to accommodate claim without alleging a constructive discharge. While you all are not bound by the federal appellate decisions with respect to the ADA.
I thought she did allege a constructive discharge. I thought that was one of the main arguments in her appellate brief.
I almost didn't cite it because I think that it seemed like that the plaintiff was assuming that she had to, but I wanted to make sure that this court knew that the 10th Circuit has opined that you do have to. And the reason I raise it is because it's yet another reason.
But this is what I'm asking you. Tell me why she didn't allege a constructive discharge. I thought she did.
Well, she tried to, but she didn't sufficiently provide factual allegations that would support the theory. Here's why. For one thing, there's a long line of cases, and it's the ones that the trial court relied upon to say that where a plaintiff abandons the interactive process when the employer is going back and forth with her with respect to proposed accommodations, that when you quit, that does not support a constructive discharge. There's yet another alternative argument that we made, but the trial court didn't reach, concerning the statement, we have to reach the agreement or be fired. Now, I propose that that statement related to making the return to work agreement a condition of employment which I submit, again, is not even an issue of this appeal. The cases we cited that it's fine to do that when we have an employee with admitted substance abuse problems. Moreover, the record is clear that the person making the statement, allegedly making the statement in this meeting, the assistant city attorney, had no authority with respect to the employment of the plaintiff. And I looked, we could find no case where, and as a matter of fact, we cited a case that notes the lack of cases nationwide, apparently, where threats by a person who had no ultimate employment authority over the plaintiff.
Did those cases talk about apparent authority at all?
I don't believe they did. I looked at that too, however, and
Because it seems to me as that a certain amount is delegated to the individual who did conduct this meeting, and this person was in a fairly responsible position, and it's hard for me to believe that there isn't some type of apparent authority under which someone is pressing the matter on the employee.
I understand the position. Again, it is a third, you need not decide the issue to affirm this case. But I think the same argument was made in the decisions that we cited where the threats came from someone else who ostensibly was important enough to make the threats and have them taken seriously, but wasn't the person's supervisor. Furthermore, we're all held to know the law, and it's published authority by virtue of the city ordinances and the city charter designating the city manager as the ultimate arbiter of Ms. Leverage's or the plaintiff's employment. So with that, if there are no other questions, I see my time's about to expire. We ask that this court affirm the district court's ruling dismissing the case as a matter of law.
Thank you, Your Honors. Once again, the defendant is conflating negotiation of the return to work agreement with a request for an accommodation. The request for accommodation was a request related to her diagnoses of anxiety and depression. The return to work agreement was the employer's effort to control Ms. Leverage's behavior both inside and outside of work.
Counsel, can I just ask you, is there something that says that those two things can't be negotiated at the same time? The discussion can't cover both?
No, there is not. And I maintain that when she asked for a reasonable accommodation for her anxiety and depression, the response was, well, we'll modify this agreement. The agreement had nothing to do with those diagnoses or those illnesses. So saying, well, we'll modify this agreement, which if you don't sign it, you're fired, does nothing to create a reasonable accommodation for the anxiety and depression. Not only that, but when they say that it was an unreasonable request, they do not cite any of the reasons that the statute allows as a defense for a reasonable accommodation. They don't cite to undue hardship. They don't cite to a concern for safety of others or the plaintiff. They say it's not reasonable because of this agreement. And
Was there something, though, that prevented her from this interactive process, whether it was for both an accommodation as well as renegotiating the terms of the return to work contract? Was there something that prohibited her from specifically saying, that's not what I need instead X?
She did. She said, I need to be able to self-report.
Right, well, to self-report, but after they said, well, no, we're not going to let you self-report, it didn't seem as though there was any response from her saying, this is why it doesn't work for me in order to accommodate the
Right.
disabilities
And,
I have.
and that's actually, I don't believe that's required of the plaintiff at that point, because it was a reasonable request. It was plausible, and it would be effective in meeting her needs. Their denial of it was unreasonable. She's not obligated then to keep coming forth with, well, what about this? What about that? They came up with an unreasonable accommodation without justification. It didn't meet any of the defenses that are allowed under the statute. And she said, well, if you're going to force me to sign an agreement with which I do not agree, then I will have to resign. The resignation was really in response to the terms of the return to work agreement. So the return to work agreement negotiations and the discussion were intertwined. And I see my time is up. Thank you.
Thank you, counsel, for your arguments in the case. The case will stand submitted and opinion will issue in due course. Thank you all. Do you need a break? Case is Trujillo versus Regional Transportation District. Council are sitting at the table, and I presume ready to proceed. When you first came in, did you get the oral argument instructions?
Your Honor, I am familiar with them.
You are familiar with them, okay. How about yourself?
I have them here.
Okay, do you have any questions about them? Okay, the only two things that I will add to them is don't mention anything that's sensitive or confidential. I'm not sure that would apply to this case. And the second thing is when you come to the podium, please give us your name, attorney registration number. The third thing I'll add is for those in the audience, please turn off your pagers or your cell phones so as not to obstruct the oral arguments in the case. Remember, they're being live streamed. They're also going to be recorded on our website. With that, I think we can begin the arguments in Trujillo versus RTD.
Thank you, Your Honors. Derek Black, attorney registration number 37919, on behalf of Appellant Regional Transportation District. Your Honors, we have three main points, and we think they all merit your attention. But the utterly decisive point, and the one I would like to address first, is this, is that the General Assembly in 1992 amended the Colorado Governmental Immunity Act to include the definition of sidewalk. And not just any definition of a sidewalk, but as the Court of Appeals in Calusi v. Town of Vale stated, a specific and technical definition. Whereas that sidewalk is the portion of a public roadway between the curb lines and lateral lines of the travel portion and adjacent property lines. The trial court erred by summarily concluding that the Civic Center Plaza walkway was a sidewalk without conducting the specific and technical fact-finding necessary. Location matters. In fact, the General Assembly made a distinction between sidewalks and walkways for purposes of waiver of the Colorado Governmental Immunity Act. By not conducting that specific and technical fact-finding, the trial court's order would lead to absurd results. It would mean that every public plaza, walkway, or parking lot will become a sidewalk subject to waiver under immunity for 2410-1036. As an example, we can look towards the Denver District Court, where there is Bannock Street, which is a deeded municipal roadway, and there is a large plaza where there is a garden and where there are steps leading up to entry into that building. To conclude that that entire portion of a walkway is a sidewalk would mean that the Denver District Court is subject to liability, an unlimited liability that was not contemplated by the General Assembly.
So, counsel, can I interrupt you for a moment then? Is your main concern with that aspect of the court's order that there needed to be specific findings regarding where the property line was in order to meet that portion of the definition of sidewalk?
Yes, Your Honor, that is one of our main concerns, is that the specific and technical requirements under 2410-1036 have not been determined by the trial court. And that leads us to my second point, if I may, that the Mall Shuttle Turnabout is not a public roadway.
Can I stop you before you go to your second point?
Yes, Your Honor.
If we were to agree with you that the court didn't make sufficient fact findings on the adjacent property line to meet the definition, what is your request that we do?
Your Honor, we would ask that you remand with instructions to determine the curb lines and lateral lines of the travel portion of the roadway and the adjacent property lines consistent with Calusi v. Town of Vale, where in fact in their order they actually included a diagram which pointed out those very specific and technical requirements.
Okay, thank you.
Our second point is that the Mall Shuttle Turnabout is not a public roadway. Included within that specific and technical definition of sidewalk is the term public roadways. That term necessitates that the General Assembly intended to distinguish between public and private roadways. For if that was not the case, they simply would have stated roadways, followed by the technical and specific requirements. But they did not. And when reviewing statutory language, the courts assume that the legislature understands the legal import of those words and gives meaning and definition to each word. And here the trial court erred by concluding that the correct focus of the analysis is the purpose the road serves and who benefited by its use, and not the restrictions placed upon it. But purpose and use are not the standards. The Colorado Supreme Court in Bloomer v. Board of County Commissioners concluded that the Colorado Governmental Immunity Act only waives sovereign immunity with regards to municipal, federal, and state roads. In other words, for purposes of waiver of governmental immunity for a sidewalk, a public roadway must be dedicated and designated as a municipal and federal state road. That roadway, it must be a deeded right-of-way for a municipal, federal, or state agency for purposes of public motor vehicle travel.
And this is in the Bloomer case?
In Bloomer v. Board of County Commissioners, yes, Your Honor. In Stanley v. Adams County School District, the court considered whether the driveway at issue was a sidewalk for purposes of waiver of governmental immunity, and whether it was within the lateral lines of the right-of-way of the adjacent roadway, the right-of-way of a municipal or federal or state road. The mall shuttle turnabout in this instance is none of the aforementioned. It is a driveway. It is wholly owned by RTD.
And what findings were made to determine that aspect?
Your Honor, the trial court concluded that neither party disputed that RTD wholly owned the the Civic Center Plaza walkway and the mall shuttle turnabout.
And so it was her finding, therefore, that because RTD was a municipal entity, that its ownership of the driveway therefore qualified it as a municipal road?
Your Honor, I'm not sure the trial court even made that determination. The focus of the trial court's ruling was that restrictions should not trump the use, or the specifically the court's focus of the analysis, the purpose the road serves and who benefited by its use. The trial court did not make such determination about whether RTD, what type of road the actual mall shuttle turnabout was.
So is it RTD's position that if a municipal entity, if I'm using that as a descriptor for RTD, their ownership is somehow different from what's anticipated to be a municipal roadway within the definition?
Yes, Your Honor, that is correct. The Civic Center Plaza is located within the municipality of Denver. RTD itself is not a municipality for purposes of governmental immunity. We are a political subdivision.
So do there need to be additional factual findings made by the trial court with respect to the driveway in order for us to know, according to your position, whether it would fall within that definition?
Yes, Your Honor, we believe that to be so. First, there needs to be specific and technical findings related to whether it is a sidewalk by examining the curb lines or lateral lines, and there also needs to be a determination about the road. That's, we believe, what the Colorado Supreme Court in Bloomer v. Board of County Commissioners stated, is that it needs to be a municipal road, it needs to be a federal road, or a state road for purposes of waiver of governmental immunity. RTD is neither of those. Moreover, if, as the trial court suggests, purpose in use would become the standard for determining whether a paved surface was a roadway, public roadway for purposes of waiver of GIA, it would mean that every driveway or parking lot where a public entity is transporting members of the public would become a public roadway for purposes of waiver of the CGIA. It would mean that school buses and their driveways and parking lots would now become public roads for purposes of waiver of CGIA. It would mean that pre-convicted litigants who travel to court, that court location, whether it be a driveway or public driveway or parking lot, would become a public roadway for purposes of the CGIA. we believe that that is not the intent of the General Assembly. If that was the case, there would be no need for the language that is in 2410-1D1.
So does this argument depend on what you were saying earlier, that the focus was incorrect to look at the use?
Yes, Your Honor, we believe that that is inconsistent with Bloomer v. Board of County Commissioners.
All right, and if we were to disagree with that and say, for instance, in Stanley, when the focus was on the use of it, and was the use really intended for public access or not? So if we were to follow Stanley, then there would not be the concern that every single public walkway would be considered a sidewalk.
Your Honor, with respect to Stanley, yes. With respect to Stanley, Stanley considered the right-of-way of the adjacent property, and it also considered whether the sidewalk portion was within that public roadway. The sidewalk definition or waiver under the CGIA is a public roadway. It necessitates there being a public roadway under the what the General Assembly has stated, and Bloomer v. Board of County Commissioners indicated that it must be a municipal, federal, or state roadway.
Counsel, you thought the public roadway is tied to what restrictions are put on it. Is it your position that only a roadway that has no restrictions put on it is a public roadway?
No, Your Honor. The focus isn't on the restrictions. The focus is on the dedicated and designated as a municipal, federal, or state road. And it needs to be, a sidewalk would need to be contained within either the municipal, federal, or state roadway. And the only way to make that determination would be the court would have to determine whether the mall shuttle turnabout was a dedicated or deeded over to a municipality, a federal, or state agency.
And that argument is clearly set forth in your brief.
Your Honor, I believe in our reply, we specifically pointed out that RTD was not a municipality. We also included the unpublished opinion of Richardson, which also addresses the issue of right-of-way for purposes of governmental immunity.
How about your opening brief? Was that issue raised in your opening brief?
I believe yes, Your Honor, we believe on page 12 where we talk about the federal, state, and municipal highway systems for purposes of 2410-106-1D1.
And then you go on to make the argument that nothing was shown in this case that would qualify the roadway as that.
Your Honor, we do mention and we do cite Bloomer with respect to waiver of governmental immunities for public roadways and not public walkways.
You do cite it, but did you make the argument that this particular thing was not shown to be a dedicated or designated state, federal, or local roadway? Did you make that argument in your opening brief?
Yes, Your Honor, on page 15, where we state that this incident occurred in the plaza area and is neither a federal, state, or municipal right-of-way.
Okay?
And what about below? It seemed as though the district court, in saying it's not disputed that this is, that the driveway is owned by a municipality, and nobody seemed to be arguing that point that I could see below.
Your Honor, within our motion to dismiss, we did, including the Richardson case as well.
I'm sorry, you did include?
In our motion, our original motion to dismiss, we did cite Richardson and did indicate that the mall shuttle turnabout is not within the right-of-way.
Not within the right-of-way, but did anyone specifically argue that RTD was not a municipal entity which would qualify as the owner of the driveway, then making it a public roadway?
I don't believe that specific argument was made, Your Honor.
Maybe I'm missing the argument you're making to us then. I'm trying to tie what you're arguing to us now to what was argued below to the trial court and whether it's the same or there's something different?
Sure, Your Honor. The Colorado Supreme Court in Bloomer stated that waiver for governmental immunity is required to be a municipal, federal, or state road. It's our position that the Mall Shuttle Turnabout is not a municipal, federal, or state road because it is not deeded to a municipality, a federal, or state agency for purposes of motor vehicle travel.
Okay.
And I would like to reserve what time I have left. Thank you.
I'm Christopher Alger, attorney for the appellee, Kelly Trujillo, bar number 25567. May it please the court. I want to address a couple of points very quickly because that I wasn't intending to address. The first has to do with what I would say are the essential irrelevance of the property lines at issue. The definition of sidewalk says that essentially, and I'm paraphrasing here, that portion reserved for pedestrians, that is for walking, between the road or the edge of the curb and the next adjacent property line. We have no adjacent property line at issue in this case because RTD admits that it owns the road and RTD admits that it owns what I'm calling a sidewalk, that is the pedestrian civic center mall, where people must walk in order to get onto RTD's buses and in order to get off of RTD's buses. Therefore, nobody gets on or off, nobody uses that without being a pedestrian. It's therefore intended for the use of pedestrians, and it is completely owned and controlled by RTD. Therefore, the adjacent property line has nothing to do with this case. Another point on adjacent property lines is that was never raised before the trial court. There were no findings of the trial court other than, well, we don't know what the adjacent property lines were. I raised that as the appellee, the plaintiff, raised the issue of adjacent property lines for the point of saying there's no proof of where they are. Therefore, the RTD's motion has to fail. And the court found, indeed, there is no evidence on exactly where those property lines are. But right now, as things stand right now, we know that that's not relevant because RTD admits that it owns and controls both the sidewalk and the right-of-way.
So
So
what do you, oh, go ahead.
Go ahead. So your position is there doesn't need to be a specific finding with respect to where the property line is, the adjacent property line?
Yes, and as long as the defendant is conceded that it controls the sidewalk, I don't think that the adjacent property lines even come into play because the adjacent property lines would come into play to prove where there is no more sidewalk, where there can be no more sidewalk.
But
if
I'm not hearing a concession that they control the sidewalk because they seem to be arguing that what you're saying is a sidewalk isn't a sidewalk because it doesn't fall within the definition and we don't know the adjacent property line.
No, I don't think
Am I
there's-
missing?
Yeah, I don't think they're actually saying that we don't know whether it's a sidewalk because we don't know the adjacent property lines are. RTD certainly knows where the adjacent property lines are. As I understand it, their argument is it's not a sidewalk because it's not adjacent to a public roadway. And it's not a public roadway because RTD controls it, and that takes it out of the public realm. That's what I think the argument was.
Okay.
That was certainly the argument below. Now, it is changed on appeal, and the point that I made in my brief. The second point I want to make is that we are not contending that RTD necessarily has to be a municipality. This is another issue that wasn't really raised below, other than our assertion that there is no question that the sidewalk at issue falls within the corporate limits of the city and county of Denver, which is a municipality. And therefore, the sidewalk falls within the limits of a municipality. Even if it is controlled or owned by a special district, it falls within the corporate limits, that is the territorial boundaries of the city and county of Denver. Richardson did not say anything to the contrary of that. In Richardson found that the adjacent property line separated the road from what was owned by RTD. In this case, in several locations, we have admissions by RTD that it has contiguous ownership of the whole area in question, the road, the curb, the Civic Center Mall, where people are forced to walk if they want to use one of RTD buses.
Can I ask you a couple follow-up questions then? Below, and was it argued and addressed by the court that to be a public roadway, this driveway had to be specifically owned by federal, state, or a municipal entity.
Nobody addressed ownership. It was stated that Bloomer stands for the proposition that the road has to be one of the four categories, and those include state highways, federal highways, or within the limits of a municipality. But nobody addressed ownership below.
So it wasn't argued below whether it fell within one of those categories?
Only my assertion that it was not in dispute. That's correct. It was not argued.
Which may have been why the trial court said it's not disputed?
That's correct.
Okay.
And to follow up on that, so there's no argument below that it was not outside the area designated or dedicated as a municipal, state, or federal right-of-way?
That's correct. That's correct. It doesn't have to be, specifically, it simply has to fall within, it has to be within the corporate boundaries of a municipality. In essence.
It meaning the driveway? I think
the sidewalk and the road to which the sidewalk is adjacent.
I think where I'm needing some clarity is, I think I understand, I'm not sure, that RTD's argument now, I'm not necessarily clear that it was ever made below, but the argument now at least is that the driveway does not qualify as a public roadway because in order for it to be a public roadway, it has to be owned or deeded to a federal, state, or municipal entity.
That's what I just got, I heard
Okay,
RTD's
so that's
counsel
your
say that,
current
yes, just
understanding?
now. That's what I just heard, but I don't think that's ever been briefed. I don't think that issue of ownership has ever been really addressed, or whether it needs to be owned by the
And
municipality or the
Is it
special
your
district.
position that we don't need to figure that out because the admission, as you see it, or concession by RTD, that this entire plaza area, including the driveway and the walkways and the plaza, are all owned by RTD? It's not a matter in dispute?
That's actually a separate issue. The issue of whether or not the property lines separate the sidewalk from the roadway relates to the statutory definition of sidewalk.
Sidewalk, right.
But the issue of whether or not the roadway is a public roadway and whether the fact that it's owned by RTD takes it outside somehow the corporate limits of the municipality, that's a separate issue that falls into the waiver provisions, D1I of the government immunity statute.
And that's the
a separate argument.
language of the statute.
That's correct, Judge. That's what the other thing I want to point out with respect to Bloomer is very specific that, on page 945, that public roads include any public road, street, or sidewalk within the limits of a corporate municipality. The issue in Bloomer was whether county roads. That was it. That was what Bloomer addressed, and that was what Bloomer ruled on. It never even suggested that a special district's road used by the public, promoted by the district to be used by the public, necessarily used by the public in order to get to the mass transit vehicles, which are statutorily called public transportation vehicles, as the trial court pointed out in her order. There is nothing having to do with Bloomer, nothing in Bloomer relating to those questions at all. All Bloomer said was that there are four types of roads, and one of the kinds of roads it described is exactly the kind of road we think existed, that it was next to the sidewalk where my client fell.
And within the corporate limits of the city and county of Denver.
Unquestionably, admittedly.
No, that's part of your argument.
That's correct, Your Honor. There's no special carve-out for special districts. In fact, they're specifically mentioned within the GIA, any special district. So if special districts are somehow excluded from the GIA because they fall, to the extent they fall within the corporate limits of a municipality, then that means that special districts, unlike any other government entity, no longer has any exposure to the dangerous conditions it puts on its sidewalks. And I seriously doubt that that was the intention of the legislature.
And this argument was not addressed to the trial court?
No, it really wasn't, Your Honor. The argument has sort of evolved over time, and it seems to change upon with every paper. The argument before the trial court was, this isn't a public roadway because the public can't drive its cars on it. That was the argument. That's what we briefed. Now, I raised the additional issue of adjacent lines, thought it was a good idea, and now here we are on appeal talking about, gee, maybe not. But I thought at the time that the only thing that they had raised was whether or not, and frankly, we didn't think it was that much of an argument. It seems pretty obvious that the 16th Street shuttle is public transportation. Only the public can drive on the 16th Street shuttle. There's no private transportation allowed. And that even leads to the absurd construction of the statute that to the extent that private people can't use the road, it can't be public, which doesn't make any sense at all. Of course mass transit is public. Of course the 16th Street Mall turnaround is a public road. It can't be anything else. It's not an access road. It's not a special road limited to the conveying of students or prisoners. It's for anybody seeking to use the 16th Street shuttle. And RTD hopes that that's as many people as can possibly use it. They promote people using it. They try to get the public on it. For them to take the position that this isn't even a public road, it's their road, is, I don't think, tenable, given the purposes of the government immunity statute. A couple of other things. One, RTD argues that the statute needs to be strictly construed, but what it doesn't catch is that the statute needs to be strictly construed against RTD, not in its favor. The government immunity statute is in contravention of a common law, and I believe that's in Plumer. So RTD has to come up with a fairly compelling reason why it should be exempt, alone among other various government agencies, from the control of the statute for the sidewalks and roads that it creates, designs, builds, and maintains. Second thing, the argument about public policy, there's no need for the court to even address that, because there's no ambiguity in the statute that the public policy argument sheds light on. There may be some ambiguity, at most, with the word public, but that can be resolved with a dictionary. It can certainly be resolved through resort to the way the word public is used in the rest of the Colorado revised statutes, as the court did. But there's no need to consider the question of public policy or legislative intent if the plain language of the statute satisfies. And here I believe it does. And with that, I'll rest. Thank you.
In your honors, in my remaining time, I would just point you to the order issued by the trial court, where the trial court stated that the court was unclear, the evidence was unclear as to the extent of the property lines, and these determinations need to be made pursuant to the specific and technical definition of 2410-1036. Thank you.
Thank you, counsel, for your excellent arguments. The case will stand submitted. Opinion will issue in due course. Thank you all very much. With that, business of the court is concluded this afternoon. Court will be in recess, and the bailiff will so announce.